Hi everyone, and welcome to today's webinar on how to make use of the National Domestic and Family Violence Benchbook and the Queensland Domestic and Family Violence Protection Act 2012 Benchbook. Before we get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. In Brisbane, they are the Turrbal and Yagara people. I wish to pay my respects to their elders past, present and emerging, and acknowledge the important role Aboriginal and Torres Strait Islanders continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. This presentation and webinar is for professional development and education purposes for Community Legal Centre staff and is not intended to provide legal advice. It is not to be used for commercial purposes without the express permission of the authors. Information is current as of the 17th of April 2019. Today, we are joined by Heather Douglas from the UQ Law School, Rachel Neal from Women's Legal Service, and Colette Botts from Caxton Legal Centre, who will be taking you on a guided tour of the National Domestic and Family Violence Benchbook and the Queensland Domestic and Family Violence Protection Act 2012 Benchbook. I'll now hand over to Heather, Rachel, and Colette and talk to you again at the end of the session.
Hi everybody, it's Heather Douglas here. I was involved in the development of the Benchbook, and I just wanted to give you a little bit of a background about how it came into being and why it came into being. Basically in 2010, some of you may remember the Australian Law Reform Commission commissioned an enormous study of how legal systems interact in relation to domestic and family violence. And any of us working in domestic and family violence know that at any given time, a person who is experiencing domestic violence might be involved with a whole bunch of different systems of law, including family law, protection orders, criminal justice process, and so on. So this benchbook was recommended by the ALRC as one of the outcomes of their report to try and ensure that there's more consistency across states and territories in relation to responding to domestic and family violence, but also greater consistency across systems in relation to responding to domestic and family violence. It took a full year to develop the first part of the benchbook, which was sections 1 to 6, and then we took the second year to develop the second part of the benchbook. And possibly some of you listening were involved in consultations around this because we consulted widely, and because the benchbook staff were all based in Queensland, Queensland CLCs did a significant share in relation to the consultation process because we didn't have a lot of money for consultation, so we were very reliant on people in Queensland. Having said that, though, we did consult more widely with people in other states, and we had a group of stakeholders, both from the judiciary and also other interested stakeholders, places like ANROs, CLCs, private law firms, and other organisations, Australian Institute of Criminology and so on. At the very bottom, you'll see the acknowledgements section, and there's a range of acknowledgements there that you can see if you want to have a look at those as to all the stakeholders that we talked to along the way. There is a section, Purpose and Limitations of the Benchbook, and you can read about its history a little bit there. Certainly the idea was that this should provide a resource for judges who are dealing with domestic and family violence. We are particularly concerned about magistrates dealing with individual jurisdictions and maybe having to work into understanding a bit about family law and maybe understanding more complex criminal law matters and how they might be dealt with in relation to domestic and family violence. So to try to bring them up to speed on these various issues. So that was one of the things, to equip them with information, but also, as I said, to try to harmonise the approach to domestic violence. Obviously the law is not harmonious. There are different laws across the country and from jurisdiction to jurisdiction and issue to issue. So there are limitations to that, but as far as possible to try and improve that consistency. The benchbook, the National Domestic and Family Violence Benchbook, is now the resource manual for the National Judicial Council's training for judges and magistrates on domestic and family violence. So they use this resource to get judges and magistrates up to speed in relation to understanding the dynamics and so on around domestic violence and the terminology and so on. So we're going to basically take you through the bench book over the next little while, and there'll be plenty of time to answer questions, but the best thing you can do is probably spend 20 minutes just having a look around it yourself. There is a section called Using the Bench Book, and that gives you, if it comes up, which it might not right now, here it is, which gives you a diagram of how the bench book actually works and you know, how to use particular parts of it and the drop-down menus and so on. So we're going to just, hopefully this is all going to work okay. Now you'll see there's the list on the side. If you go back to the home page, you can see this is expanded out, this fully expanded out on the home page, the table of contents, but each chapter opens up here as well. So I just wanted to look briefly at a couple of issues. Basically, as I said, this was the first part of this was introduced in 2016, second part in 2017, and then a full update was done mid-2018, and we're working on an update for mid-2019. So Rachel's going to talk about this, but there's some family law issues that obviously will need to be updated, possibly in the near future. Certainly some of them will be updated in the near future, and there might be quite significant updates not far from now as well. So, you know, you need to take care when using this, recognising that it's only updated every year. So that means the case database has its limitations and references to legislation have their limitations. So it's very much this notion of understanding the concepts broadly rather than being a legal resource that is absolutely up to the minute, although the case database is very significant and a lot of those cases have precedent value way beyond, you know, obviously the moment that they're made. So it's still certainly very relevant. So if we go into terminology, you'll see there are several parts here. I wanted to take you into one of these sections, perhaps sexual and reproductive abuse, just to show you what you can see when you open up these particular sections. And all of the terminology sections look similar. So we go into this section and you'll see that you get a broad brush statement of the kinds of general information about sexual and reproductive abuse. And I'm not able to see this, but you probably can see this, that there's a print function. Yeah. So there's a print function here. So you can actually print out a function that will make it easier to copy and paste from the bench book. But also, if you have clients who are telling you something and you think this might be a useful summary for them, you might be able to print it out and give it to them. There are also within the text, you'll see there are links to other parts of the bench book. That's the orange text. And there are links to resources in the bench book. And these resources can be found in these sections above. So the green ones relate to other bench books. The blue ones relate to key literature. And then there's other resources as well. So all through the bench book, we use those same icons. So if we, for example, go into key literature, you'll see that we break it up into Australian literature and international literature. This is a bit of a rough breakdown. It essentially relates to where the research was undertaken rather than who did the research, but roughly it relates to Australian versus internationally undertaken research. And you can then open up all of these various sections and you can get a summary of how that's relevant to the particular issue that we're citing it for. And you can also click here and you can get to the primary source if you want to have a look at the primary source, perhaps download that for a client or take it into court or whatever it is you want to do. Some of these resources are going to be able to be taken notice of by judges, like, for example, Australian Bureau of Statistics material. Other material less likely to be taken into account in that context, but certainly helpful background information for you or for clients you're working with. The other bench book set is the same, so you can go into current bench books of other jurisdictions and you can look in other jurisdictions and click on the link and get to those other bench books, which might be helpful for you to look at the kinds of directions that are given in this context or other cases that are cited in those other contexts. Other resources usually relates to things that aren't research outputs or bench books. So they might be fact sheets or position statements. So here, for example, we've got a position statement from the Royal Australian and New Zealand College of Obstetrics and Gynecologists on female genital mutilation, and there's a impact of trauma statement from Echo Parenting Education, which is a fact sheet about those issues. So they might be helpful for you as well, and you can also open those up to just see exactly what they are that we're referring to and click on them to get the links. There is a set of victim experiences available to the bench book. These have been collected both from research I've done, talking to women who were referred to me by places like Women's Legal Service and other organisations, and you can click on the keywords of these, mostly women, but there are some men's stories in these case studies. And their experience of these particular issues that are listed in the keywords, and these particular keywords link back to other parts of the bench book, or you can just read, for example, Celia's story about sexual and reproductive abuse. And again, there might be stories here that speak to the experience of one of your clients that might help them feel that their story can be understood and that they're not alone, so they can be downloaded as well. Probably most relevant for many of you working in the courts is the cases section. Where possible, we've collected cases which are also in the case database, which Rachel will take you through later. But these cases just provide a snapshot of cases and what judges have said. So one of our aspirations with the National Domestic and Family Violence Bench Book is to nudge judges, and what better way to nudge judges but by comments that their brothers and sister judges have made in the past about these particular issues. So we've tried to include cases where we think judges have picked up on the literature and the understandings that we have now from research about domestic and family violence. So, for example, one of these I looked at the other day was particularly good. So this judge, for example, Justice Crawford, in relation to this Tasmanian case, and it's a Supreme Court case, so would be persuasive for a magistrate in Queensland. Basically, he talks about rape being a crime of violence, domination and degradation, and usually causes great psychological trauma to the victim and so on. So there might be cases here that you can reference to demonstrate that judges take these kinds of issues seriously, and they've looked at them in the context of the dynamics of domestic and family violence. So these are the kinds of cases we've picked up in this section. When you click on these, you'll get back to the case database to get a whole picture of the summary of the case, and then you can click from the case database into the OSLI full version of the case. Each of these sections basically goes along in the same way. So I can imagine that some of you might find these sections particularly useful, especially in more areas of abuse perhaps that are less understood, for example, like reproductive abuse, which we talk about here, or cultural and spiritual abuse, for example. You might find these resources helpful for getting resources to do further research on relation to a particular issue. But I'll hand over to Rachel now, who's going to go through other parts of the bench book with you.
Thanks, Heather. I just wanted to just run through what I think the use of this national bench book has for community legal centres. This is more of a research sort of tool. You wouldn't be taking this to your DV duty lawyer sessions, whereas the state one, which Colette's going to go through later, you might be referring to while you're in court. This is useful, I think, for preparing CLEs. The case studies are particularly useful for that, myths and misunderstandings, the definitions, and also the references that are in there to the key literature is useful for CLEs, and the same would go for law reform submissions. I think it's also really useful for staff training. So there's really good commentary in the context statements that would be useful for even for volunteers who are coming in, say student volunteers coming into your centre. If you feel that they are going to be exposed to domestic violence as a legal issue and they don't have any experience in that, this is a really good resource for them to go to get an overview and to get an idea. Even if they just stick to the context statements and they don't delve into it and read the articles, the context statements are really useful for that. For solicitors, I think, who are routinely coming up against domestic and family violence as a legal issue, I think it's also useful, and allowing people to go into and delve into the key literature. It's like a rabbit warren. You could spend hours going into and just clicking from link to link. If you've got the time, I think it's a good thing to do, and it really can expand your knowledge about this area. I'm not going to be going into any content today. Like Heather said, it really is just a guide of the website. Oh, just one other thing. I think that you could also be using this in terms of getting pro forma submissions, maybe for using in the domestic and family violence courts, particularly the case database, which I will be going through later on. So I'm going to go to the dynamics of domestic violence part and just delving into two of these subsets to show you how you might be using this. The first one I'm going to look at is myths and misunderstandings. So there's 11 myths here, and there's context statements for each one. They're very typical myths that we see every day. I'm going to go into two of them. So the first one is that the separation one, that the domestic and family violence will stop when separation occurs. We know that domestic and family violence escalates, and a risk period is at separation. And so we click on that and we can see the key literature on these issues. And in some cases you'll have references to the particular pages, not that one, the particular pages, this is that are relevant. So it's this one. So domestic violence is seen as a relationship issue, with pages that refer to that. So the other one that I wanted to look at, the myths and misunderstandings, is that women make false or exaggerated claims of domestic and family violence to gain a tactical advantage in parenting proceedings. So there was, if you click on that, you'll get the links to that. There was an article here that is really interesting. It was a longitudinal evaluation. Was it a longitudinal one? No, of the 2012 family violence amendments, and it's really worth looking at. So that opens out to the citation, and then if you click on the link, it'll go to the website. That could take a little while to load. But that looks at whether the 2012 domestic violence amendments were, that's not going to load, sorry. Whether they were helped in the area of responding to family violence. I'm not going to go through the content of that, but that's a really interesting thing to look at. Okay, so the other one I'm going to look at is risk factors. Anyone who's working in the area of domestic and family violence law should know about the risk factors, and it's a really important base knowledge to have, and this overview and the context statement will provide that. It looks a little bit different. So the past one, the myths and misunderstandings, you clicked on each myth and then it opened out, whereas this is like the one that Heather first spoke about at the beginning. There's links to the other resources. Will be, as Heather said, you've got reports, government reports, as well as literature, academic literature. I'm going to take you through a couple of these. So the first one is the non-fatal strangulation. There are links to academic articles here as well as to training materials, and it's worth pointing out this as an issue. Now, there's been a spotlight on non-fatal strangulation within domestic violence in the last few years. Of course, we've now got the standalone offence, and it's something that a lot of practitioners don't know about, the seriousness of this. So if we click on the US research, it'll take us to a training institute of strangulation prevention website. Now, we know, and it's in the context statement here, that loss of consciousness from strangulation can happen within 5 to 10 seconds and death can occur within 4 to 5 minutes. It's very, very common for clients to be reporting strangulation when they're talking to us about domestic violence, and I think it needs to be taken more seriously than it is in some cases. It's a medical issue, and clients particularly need to know the risks, the short-term risks, but also the long-term risks of strangulation. Now, this website has got some fact sheets. This is a fact sheet that is widely used that you could be using to give to clients. We actually, when we send out emails after domestic violence court or in our precedent emails about making domestic violence applications, we send out we attach this, not this particular fact sheet, but we attach a fact sheet so clients can see it. The fact sheet that we attach is actually in resources here, and it's particularly for clients. It's in, yep. So this one here, if you click on this, it's quite confronting as a visual, but it's not going to let me click down. Sorry about that. If you can log into that, it actually has a second page which gives more medical information and allows people to record and monitor their symptoms after this happens to them. Just for all practitioners who come across people who report strangulation, if it's happened, particularly if it's happened recently, or even if it hasn't happened recently, you should be referring your clients to see a doctor because it can have long-term impacts on people. And so you could be using this particularly to give to clients and make them aware of these issues. I'm also going to go into risk factors. Suicide as a risk factor, suicide threat by the perpetrator. From my experience and my colleagues' experiences in court, it still is sometimes difficult, and we notice a reluctance of police and some magistrates to recognise suicide threat by the perpetrator as domestic violence itself, or as a risk to children as well. So this has got some really interesting statistics and articles about that. There's links to the Queensland State Coroner's Office, to the Domestic Violence Death Review team in New South Wales, and there's actual reports from government bodies that you could be using in court to show the magistrates that it is a risk, and it increases the risk of murder suicides to the victims of domestic violence. It can also be really useful if you're preparing CLE or law reform materials. Okay, I'm going to hand over to Colette for a minute.
Hello, this is Colette here, and I will now be doing a quick run through on the vulnerable group of older persons. So I'm just clicking on that there. All right. Sorry, just give me a moment. I'm just going to find it. Vulnerable groups and older people. All right, excellent. So the context statement on older people highlights how the abuse of older people can fall outside the traditional conceptualizations of violence. And the bench book lists examples of the types of abuse against older people. So you can see that it's got a list there. And notably, it provides examples such as financial abuse and gives some examples like undue influence over decisions about wills or powers of attorneys, forced or refused entry into a nursing home, and threats not to see grandchildren. So if you have a look at the list there, it also refers to psychological abuse, neglect, and also notably it refers to social abuse, which is less talked about in domestic violence matters. And it refers to social abuse including not permitting visitors or making visitors feel unwelcome or fearful, which is something that we see quite a lot of at the Seniors Legal and Support Service at Caxton. As the others have mentioned, you can see these little icons here being links to key literature, where you can then see some more comprehensive information about the various forms of elder abuse. And if you click into that, you can see the various articles available, and you can click onto the articles themselves to get some more comprehensive information again. The bench book draws a good comparison between the similarities and differences between intimate partner violence and elder abuse. And if I just scroll down there, you can see that there's a table highlighting those similarities and differences. And just to note a few of the ones that stand out, similarities include a reluctance to report abuse, a fear of loss of relationship, and a sense of responsibility of the person who's being abused. And looking briefly over in the differences column, most notably, elder abuse is more often intergenerational than spousal, and that financial abuse is the most common form of abuse, which might be in the form of an adult child refusing to move out and not contributing to utilities, for example. And if I just scroll down to the bottom, there's a more in-depth example of the type of financial abuse towards older persons that we see a lot of, which is in relation to disputes in relation to family agreements, which would typically be, and as is detailed here in the bench book, where an older person transfers property to a trusted person, usually in exchange for ongoing care and housing on an understanding that that will be for the rest of their lives, with no written agreement, which results in a risk of homelessness and a loss of proceeds when the promise of ongoing housing is withdrawn, often by the adult child. If I just go back up a bit, I just wanted to highlight that the bench book highlights the relationship dynamics that lawyers should consider when assessing risk and assessing what types of orders to seek in the context of intergenerational abuse. And as is referred to here, those risk factors include family dynamics and living arrangements, an adult child in difficulty, such as where there's marital breakdown, mental health issues, and drug abuse. Very common one, sense of entitlement by adult children in relation to their parents' assets, and social isolation. If I just scroll down to the bottom paragraph there, I'll note that the bench book refers and highlights well the barriers in reporting elder abuse, barriers which increase the vulnerability of older persons, which include a lack of awareness of what constitutes abuse, and older persons not wishing to tell authorities about abuse because of a generational belief that abuse is a private matter. And once again, if you click on the links, practitioners can see the various literature that expands on the information provided in the context statement. Essentially, the context statement provides a good overview of relevant considerations for lawyers who are assisting older persons in domestic violence matters, and how those considerations can differ from intimate partner violence between younger persons. I'll now have a brief look at the tab Other Bench Books. The National Bench Book refers to section 5.10 of the Victorian Bench Book, which I've just opened up there, which provides much more information specific to elder abuse than is contained in our Queensland Bench Book. Our Queensland Bench Book provides very limited guidance on how to approach abuse towards older persons, save for a brief reference to the principles in Section 4 of the Queensland Act, which simply identifies elderly people as a vulnerable group. But if you follow the link to the Victorian Bench Book, and then if you go, I'll just give it a moment to come up. But I'm just about to click into Section 5. Then if I go to 5.10, Abuse of Older People, and then if I click on the subheading, Forms of Family Violence Experienced by Older People. If I scroll down to the bottom there, there's a box that says Judicial Consideration. And there it suggests specific conditions for protection orders that prohibit elder abuse. So just reading what's there, it includes orders prohibiting the respondent from denying the older person access to medical treatment, and an order prohibiting any behaviour that unjustly or unreasonably interferes with the ability of the protected person's ability to use and manage their own financial assets. Although I've not yet come across or ever sought myself an order in that kind of wording in Queensland, Section 58 of the Queensland Act specifies that the court may impose conditions that prohibit stated behaviour and that would constitute domestic violence. So arguably there is scope to seek such conditions under the Queensland legislation, and in that regard the National Bench Book can be a useful tool to learn from the approaches used in different states. Now, going back to the Bench Book and going into the tab Victim Experiences at the top, just to give a really brief run through of what's contained there. As you can see, the tab links to 3 detailed case studies, and those studies provide useful snapshots of matters that demonstrate the various complexities involved in elder abuse matters. And another thing that these case studies do really well is that they provide practical examples of the benefit of the multidisciplinary approach that the various seniors legal and support services take, which is a model that provides both lawyer and social worker assistance. And all of those case studies detail the kinds of work that are done by both lawyers as well as social workers. So that concludes that section. I'll just hand over to Rachel for the next part.
Thanks, Colette. I'm just going to go firstly into the case database, and I think this is one of the most useful for people who are practicing in court. We had a pre-question that came up, which was whether you can ask magistrates and judges to take judicial notice of the bench book. I think the answer to that really is that best practice would be to be using this to refer to actual cases. Judicial notice of bench books. Heather mentioned, and she's now left, but she mentioned that there are some cases around judicial notice of bench books, and I'd be happy to try and find those and ask Amanda to circulate those if people would like that. But certainly the case database is really useful. So it is up to date, like Heather said, as of June last year, 2018, and it states in the preamble here that it's been the efforts are aimed at encouraging, where possible, greater consistency in the handling of domestic and family violence cases and the application of laws both within and across jurisdictions. I would say that consistency in these matters within our state, at least in Queensland, has not yet been achieved, and it's one of the major barriers that we face as advice lawyers, particularly in terms of advising clients as to how their matters are going to go, because there is a lack of consistency between registries and between actual magistrates. So there is great utility in, if you are practicing in court, whether you're appearing in hearings or whether you're appearing as a duty lawyer, to reference cases to try and encourage that consistency. Cases have a great deal of power in court, obviously. You could use these cases to develop pro forma submissions that could be used in asking for temporary protection orders and have those ready for when you're going to court, whether you're a duty lawyer or whether you're actually running hearings. The case database is fairly self-explanatory. If you click on and open that up, there are all cases, and then it's divided into Commonwealth and then each state and territory. So, and then within those you'll have you'll have the types of courts, so each court. If we go to Queensland, You can go into the district court where you'll have appeal decisions in relation to this matter. The Supreme and Court of Appeal matters are generally more about breaches of protection orders is what my observation would be, but the district court decisions will be more applicable to the application of the Act. There is a search function, and I was just going to go into that. So that's up the top there in the right-hand corner. I'm just going to search for abuse of process. Let me click on that. It will search. It's going to take a while. Yep, it will search the whole site if you want it to do that, which will bring up the commentary and the context statements as well, which can be useful, of course, or you can just search the case database. And then it will just bring up the cases, and that will be in all of the jurisdictions. I'm just going to show you another search that may be useful. So if you wanted to search cases that deal with necessary or desirable or necessary and desirable, you can search the case database and you'll get up a number of Queensland District Court and other matters, of course, but you'll see mostly Queensland matters because that's the terminology used in our legislation. Again, I think that those cases are really useful to be referenced in pro forma submissions, particularly when you're talking about getting temporary protection orders. It's not just appearing in court, though. We, of course, all know that a lot of our clients represent themselves in court, and it can be useful to give them pro forma submissions that they may use. We certainly have a lot of clients who self-represent in final hearings because we don't appear in final hearings. We just do the duty lawyer mention and interim work. And a lot of clients who have the capacity to use written submissions find that useful, as long as you can explain to them how precedent works and what the use of cases are. So that's the case database, and I would definitely recommend that to people. I'm now just going to go into the family law proceedings section. This is a really comprehensive overview of the family law system, and I think that it's useful as an overview for non-practicing family lawyers as a refresher or as a reminder of the issues around family law. It's useful for practicing family lawyers who are working with people who have experienced domestic and family violence, because it does specifically reference family law and its intersection with domestic and family violence. It can also be useful, these overviews. You may find some of the context statements that would be good for printing out for clients. There are a lot of resources about family law around, of course, but having looked at this over the last week or so, I think it is a really good overview, and it does look at family law system from that lens of domestic and family violence. I'm just going to look at a couple of the subsections of this. First one is the intersection of legal systems, which is always an interesting thing to look at. The context statement there talks about how the domestic and family violence jurisdictions, family law jurisdiction and child protection systems work together, or maybe the case don't work together, and that is worth a read. There's a good range of key literature in this section. Of note, the Family Law Council reports here, which were done to the Attorney General about families with complex needs and the intersection of family law and child protection systems. So the final report came out on that in June 2016. That is definitely worth a look. As an aside, like Heather said, family law system changes rapidly, and we've now seen the release of the Australian Law Reform Commission report on the future of family law. Anyone who wants to look more deeply and in a more current sense into this issue, I'd recommend that you read Chapter 4 of that report that was released last week. That's titled Closing the Jurisdictional Gap, which goes into that in more detail. out of that report has come a recommendation that the states look at taking on more family law matters. The way that will look, we don't know yet, and it's worth reading the chapter to get a more deep idea, and probably the ALRC report, it could be the content of a whole webinar in itself. But it's interesting what Heather said, that you need to look at the references that are here and realise that there can be changes to the law, and that you need to look at more recent reports and issues that are happening as well. So Chapter 4 of that report is something that I would recommend people look at. Finally, I'm just going to secondly, I'm going to look at close that. Sorry. Self-represented litigants. Self-represented litigants are, for our service at least, and I think for most CLCs, are a big proportion of the clients who come in. And it's certainly for most services that provide mostly advice, that's what we're helping them to do, is to explain the legal system to them. So there's information here about how the courts are supposed to deal with self-represented litigants. There are guidelines to the best practice guidelines of the family court, which you will see there. And they're really intended to assist judges. It's best practice. It's certainly not what we see happening every day, but we do see best practice occurring, but it's important that we know what that best practice should look like when we're advising people who are representing themselves. There's also the if I go back to that, sorry about the silence. The self-represented litigants back there. There's the self-represented litigant project that was run by the Family Court of Australia. So there's links to that there as well. That's worth looking at, which has got a number of, it's a project report, so that's quite old, but it is also worth having a look at. I would say another update in terms of self-represented litigants that is worth noting is that there are recent amendments, legislative amendments, that are about limitations of cross-examination in person. There are fact sheets on the Federal Attorney General's Department website about that, and it outlines the limits on cross-examining people in the other party in person if there are family violence orders in place or there are allegations of family violence. It's an area that is really important for anyone who's practicing in this area to get on top of. It means that if there are cross applications for domestic violence, there are limits to the cross-examination that can happen. Now, the way that is going to be established in the courts is not clear. So there is has been announced by the federal government that there will be a project for representation so that cross-examination can be done by lawyers. It's not clear yet how that is going to look, and you just need to watch this space. But in terms of more updated information about self-represented litigants, it's important to be aware of that. And I recommend that you have a look at the Attorney General's website and have a look at those fact sheets. The final thing I'm going to look at here is information about property proceedings. It gives a really broad overview about how property is dealt with, but then it also looks into how family and domestic violence as a factor is taken into account when they're looking at property orders. So the leading authority is the case of Kennan, which states where there's a course of violent conduct by one party towards another, which is demonstrated to have a significant adverse impact on that party's contribution, it should be taken into account. The reality is that it often doesn't make that much difference, but it is an important thing for anyone who is giving advice on property, family law property matters to be aware of. There is other research there that also talks about how family and domestic violence might affect the share of property and other financial resources that are worth looking at. We are going to run out of time here, so I'm going to hand it over to Colette now, who's going to talk about the Queensland Bench Book.
Thank you. So I'll just talk quite briefly about the Queensland Domestic and Family Violence Bench Book. If I bring that up, hopefully I can. Yes, awesome. All right. So we thought that it would be prudent to touch on the Queensland Bench Book as well. And what I'll do is highlight the fact that the Queensland Bench Book may be more beneficial to practitioners to obtain guidance on local issues. So all I'll do is highlight a handful of those issues in which the Queensland Bench Book provides some succinct direction. So the first thing that I'll look at is ouster orders. So if I just see if I can find that. It's of course much less comprehensive. It's a PDF document. So in that regard, it's perhaps particularly useful for duty lawyers who won't have much time to research on the fly. Is that the right spot there? In any event, in Queensland, of course, the court must consider making an ouster order and must give reasons for making or not making the order. And the Queensland Bench Book provides guidance on what the court must consider before making an ouster, which is, of course, relevant to every single domestic violence matter in Queensland. I was just trying to find before, but I don't think I actually found it. 9.7. So if you have a look there, it's slightly more difficult to navigate online since it's PDF, but it really just gives a really basic snapshot and just an overview of what's in the Act. But it's just really useful to complement the Act, essentially. Secondly, I thought it would be worthwhile pointing out that the Queensland Bench Book is useful to refer to get information in relation to cross applications. So if I just go up to 3.7 cross applications. So of course, under the principles in Section 4 of the Queensland Act, the person who's most in need of protection must be identified. And the Queensland Bench Book is useful in that it, as well as referring to the background, it also refers to various case law to provide guidance on the point. And essentially, it highlights that both people cannot be a victim and a perpetrator at the same time, that cross-applications can be used to continue to victimize, and that violence used in self-defense or to protect a child can be misconstrued as domestic violence. And I thought that that would be an interesting one to point to because it's one that comes up continually in practice in Queensland, certainly as the duty lawyers in the Brisbane area. So I thought that that would be worth highlighting. Finally, in relation to the necessary and desirable test, and of course Rachel already ran through how you could seek more case law in relation to that using the National Bench Book, but once again, the Queensland Bench Book simply provides a snapshot overview, and it also details a number of cases which go to defining what exactly necessary or desirable means. So in a nutshell, it's pretty succinct. It's quite useful to refer to for those local issues, and it's certainly worth having a read of and being familiar with. And that's probably all I really need to say about the Queensland Bench Book. It's fairly self-explanatory and something that will be good to have a read through.
All right, so we've got a little bit of time for questions. If anybody has anything they'd like to ask, type it in the question box. I personally thought it was really interesting to learn about a legal resource that was really user-friendly. That's new. It's good to hear about. questions just yet. Looks like the presenters answered everything that you were wondering about.
If you want to ask how you find time to actually go down the rabbit hole, and I don't have an answer to that.
Me neither.
All right. It looks like everything's answered except how to find time to go down the rabbit hole. We've got a thank you. Thank you for that. And I'd like to thank Colette, Rachel, and Heather as well for a really great presentation, and thank you for attending. The recording will be available online later today. Thank you, everyone.
Bye.
Bye.
Thank you. That was perfect timing. I had a feeling it would be. Once we each got 2 pages.